Guys, my premium noise cancelling headphones just arrived. Why does this look like RM10 Pasamalam version?
Try it.
I can still hear everything.
Congrats, you just got legally scammed. Yes, this is exactly what contract law is designed to deal with.
Okay, pause right there. You just experienced something we all fear. Expectation, premium. Reality, pasar malam clearance sale. But let's not just laugh at his pain for a second. Let me ask you something more serious. When you buy something online and it turns out completely different, do you actually have power as a buyer? Or are you just hoping the seller is nice enough to refund you? Because this is where law steps in. Now, before we jump into UK versus Malaysia, we need to lock in one foundation concept. A contract sales of goods is not just I pay, you deliver. No. It's deeper than that. It's a legally binding relationship with rights, duties, and consequences. So once money is exchanged, you're not just a customer anymore. You are party to a contract.
So under Malaysia SOGA, which is Malaysia Sale of Goods Act 1957, the law implies certain terms into every contract, even if you don't write them. So these are called implied terms.
See, this is why people underestimate contract law. Even if yours never wrote, must be original, must be high quality, must actually work. The law already assume these things. That's what implied terms do. They basically say, seller, you don't get to play dumb.
Let's break it down simply. We have two sections. We have section 15, we have section 16. For section 15, it is sales by description. If you order premium headphones, so the goods must match that description, right? For section 16, it is quality and fitness. So the goods must be merchantable quality, means it is in acceptable standard. And it must be fit for purpose. That means must work as expected. Now, here's the most important concept in Malaysia. It is condition versus warranty, and this determines your remedy.
Wait, this part is crucial. If you remember nothing else from this podcast, remember this. Condition versus warranty is everything. Because it answers one powerful question. Can you walk away or are you stuck?
Okay, so basically, condition, it is a big promise. If broken, you can cancel the contract. But for warranty, it is a small promise. If broken, only money compensation. So in your case, since he get a fake headphones, it's already breach of condition. So he can reject everything.
So in your case, let's be real. This is not a minor defect. This is not slightly off. This is straight up betrayal. So legally, yeah, he should be able to reject the whole thing. No, not negotiate, not compromise. Just cancel and move on. But now, here's where it gets interesting. You would think the UK would say the same thing, right? Wrong. UK law looks at the situation and goes, let's think about this first.
Now, in the UK, it looks similar but actually more advanced. Under UK Sales of Goods Act 1979, the law uses satisfactory quality instead of merchantable quality. This is implied under term section 40, meaning it's applied automatically even it's not written in the contract. This is broader and more modern. The code will consider few things such as quality, durability, safety, and appearance. so it's more consumer based. The standard or is based on what reasonable person would consider acceptable. But here is the twist. UK courts don't always strictly follow condition versus warranty. Sometimes they look at as the buyer used the goods, is the defect serious or would the cancellation be unfair? These reflect a shift from strict rule to a more context-based approach in modern contract law.
And honestly, this is where students get confused. Because Malaysia is like, rule is rule, follow it. But UK is like, okay, but what actually makes sense here? So instead of black and white, UK law operates in this grey area of fairness.
So UK law is like more chill.
Well, it's not considered chill, but lean towards more flexible and realistic. It focuses more on fairness rather than strict legal classification.
More chill is one way to put it, but let's be accurate. Malaysia, predictable justice, UK, flexible justice. So it's not about which one is better overall. It's about what kind of system you prefer. Alright, time to upgrade our answers from I think to I can support this legally. Because in law school, opinions are useless without authority. You need statutes, cases, and reasoning. Otherwise, your answer is just vibes.
Here are key legal authorities, which is primary sources of law are binding and must be followed by the courts. These include the Federal Constitution of Malaysia and legislation such as the Contracts Act of 1950. For cases or judicial precedents are also primary sources where judges follow earlier decisions based on principles of state diseases.
Alright, let's explain some cases. Let's pick Billy versus Taylor. So in this case, it is actually a car was sold in one model, but actually it is a mixed part. So the court already said it is a breach of description.
Grant versus Australia knitting mills. Buyer got skin allergy from clothes, but the court rules as not fit for purpose. This case established that fitness for purpose apply when the buyer relies on seller's skill or judgment.
And notice something about these cases. This court are not just reading contracts word for word. They are asking what did the buyer expect, what actually happened, and is that gap acceptable? That gap is where liability lives. Alright, I'm stepping in as moderator now. We've got Team Malaysia, clarity, certainty, structure. Team UK, flexibility, fairness, realism. And honestly, both sides are making solid points. Because think about it. Too rigid, you risk injustice. Too flexible, you risk uncertainty. So the real question is, where do you draw the lines?
Personally, in my opinion, Malaysia have a better law because it is clear and predictable. Businesses know exactly what happens and it has less confusion in court. So this is important in commercial transaction.
But that's also is a weakness. It's too rigid. In UK law, judges can adapt to real situation, more fairness, and better protection for consumers. This is especially important in consumers protection cases where strict rule may cause unfair results.
But wait, if it's too flexible, won't businesses feel uncertain?
Exactly. That's the trade-off. Law is always a balance between predictability so businesses can feel safe, fairness so people aren't treated unfairly. And no system is perfect.
Yes, but that's why UK law balances it with case law, and precedents. Precedents ensure consistency while still allowing flexibility.
In Malaysia, we don't need that much interpretation because the Act already tells you clearly.
Okay, enough theory. Let's bring this into exam mode. Because this is exactly the kind of scenario lecturers love.
Let's make it more realistic, like an exam question. For an example, a Malaysian company imports cocoa powder from UK supplier. The contract terms are payment before delivery, and goods describes as high-grade cocoa. The problem is, goods arrive moldly.
Right, let's explain it step by step. So if the goods don't match the quality, it is already breach of condition. So the buyer has right to reject goods, terminate the contract, and then claim damages. It's very straightforward.
Now in UK, yes, breach exists, but courts also check did buyer accept the goods, how serious is defect, and can the goods still be used. The outcome may be few things such as repair, price reduction, or damages instead of termination. This sometimes refers as a proportional remedies or solution that must match the seriousness of the breach.
Same facts, same problem, but two completely different legal approaches. As in our title, same but different. And this is what gets you marks. Not just stating the law, but comparing how different systems think.
Okay audience, round 2. You bought 100 laptops. 10 are slightly defective but still usable. Do you A. Reject all goods, or B. Accept and claim damages?
Ooh, okay, this one is tricky. Because emotionally, you want to say reject everything. I paid full price. But legally, it depends. And that's the shift from thinking like a consumer to thinking like a lawyer.
In Malaysia, it is depends if the breach is condition, but most likely is A, which is reject all goods.
More likely would be B.
How do businesses avoid this problem? They put clear quality clauses.
Add inspection right before acceptance. Compare jurisdiction Malaysia versus UK differences.
Refund and replacement terms explain a customer's right if a product is faulty, damaged, or not as described. Under the Consumer Protection Act 1999, customers may request refund, replacements, or repair. Refund returns customers' money, while a replacement means exchanging the item for a new one. These remedies depend on the condition of the product and the situation.
Let me be real for a second. Smart businesses don't wait for the law to save them. They prevent problems. Because going to court, expensive, time-consuming, stressful. So the best strategy is simple. Write better contracts. If you're answering an exam question, do this. Identify the issues, apply the law, Malaysia and UK if required, compare the reasoning, conclude clearly. Don't just describe, analyze.
Your answer must have description, quality, and fitness, which is identify the implied terms.
Remedies depend on the classification of the issue and the context. Under the Consumer Protection Act 1999, the solution, whether refund, replacement, or repair, depends on the type of defect and the circumstances of the case.
So next time you click buy now and feel excited, just remember, behind every purchase there's a contract. And whether you realize it or not, the law is already involved. Thank you everyone for joining us.